Alrighty, folks, looks like we are live. I'm George, a founder of Solo. We help people resolve their debt and debt lawsuits, especially. We have on the show with us today John Skiba. John, you want to go ahead and tell us a little bit about yourself?
Yeah, George, glad to be back here. John Skiba, I'm an attorney in the state of Arizona. I practice primarily in bankruptcy and consumer debt lawsuits. I defend people who are getting sued. And I also founded the Consumer Warrior YouTube channel, which we've been doing videos for about 11 years now. Excited to be here again.
Fantastic. Thanks so much for coming on. Looking forward to chatting. So, folks, a little disclaimer up front, right? We aren't your lawyers. I'm not a lawyer. Solo is not a law firm. We aren't practicing law or engaging like legal advice here. We're just doing a webinar. If you have any questions, we reserve most of the time here for Q&A at the end. So go ahead and put any questions that you might have into the chat on YouTube. We also have Hannah, who is on the Solo account, who will be helping us out and responding to any questions that you put into the chat in the chat as well. So whatever question you might have about how to deal with a debt lawsuit, how to deal with debt, how to deal with bankruptcy, just go and put that into the chat. We have lots of people on the show today, so I want to get those in early because we usually run out of time to respond to everybody. All right. So that said, we're talking especially about today, can a debt collection agency buy my debt? So John, how about we just start there? Can somebody buy your debt?
The answer is yes. Debts are bought and sold. When you kind of start digging into it, it's at least me initially when I started handling these cases 15 years ago, I was shocked at the scale that it happens. So most credit card accounts, once they get 6 months past due, the company will charge it off, and then most credit card companies package it up and they'll sell it off to companies. I call them debt buyers or junk debt buyers. There is a difference between you talk about collection agencies. Actual collection agencies typically don't buy debt, and that's where it does get a little bit confusing because there are companies like if you don't pay your American Express, maybe they're going to hire a collection agency to give you calls and be annoying, but they didn't actually sell the debt to them. Whereas there are debt buyers, the LVNVs, Portfolio Recovery, Midland Fundings, Midland Credit, they're actually buying the debt. They're buying it for a huge discount, and they're buying the rights to collect on that particular account. At least that's from their perspective, that's what they're saying. And then they go out, they send the letters, they file the lawsuits. And they're by far the biggest filer. Like in Arizona where I practice, second only to like traffic tickets. They clog the courts with these debt collection lawsuits. So the answer is yes, the debt can be bought. It does happen frequently. And I would say actually most of the time debts are sold from the original creditor to a debt buyer as part of the overall collection process.
Yeah, folks, I'd say I think about it I think about it as there being about four parties or so on the collection side, right? So when somebody says collector, it could be talking about the creditor, so like the person that you have a credit card debt with, like Chase Bank. You could be talking about a collection agency, so that would be once you're in collections with Chase Bank, they might hire an agency who will then try to collect on the debt for Chase while Chase still owns the debt. And then you might have a collections law firm. So if things are really delinquent, or if the creditor just wants to, maybe that's just their policy, they'll hire a law firm instead of the agency. The law firm will try to collect before a lawsuit. And then if they can't collect before the lawsuit, they'll sue you for the debt. And then the fourth is a debt buyer. So sometimes the creditor will take the debt and sell the debt to a debt buyer. That's publicly traded companies like Midland Funding or LVNV. It can also just be the guy that lives, a few blocks away from you and is buying like a few debts, right? It can just be some dude that buys the debt. So course, in that case, he has to be a licensed debt collector, but it can just be a really small time shop like that. So those are like the four players on the collections side. And in my experience, there isn't like universally there isn't rhyme or reason as to what kind of pairing or arrangement you get. Some creditors just send it to a law firm early, some do it on a collection agency, some sell off early. Uh, Usually you're working with two parties, so it'll be like a creditor and a collection agency or a creditor and a law firm. Um, Sometimes it's just one. Sometimes the creditor, like Capital One, will just represent themselves in court and sue the consumer for it, or the debt buyer might represent themselves in court as well. So that's an important concept to understand because I think that's oftentimes what people are most confused about when they get sued. They're like, well, I had a debt with Chase, I had a credit card with Chase Bank, but now Midland Funding is suing me, or maybe it's Scott and Associates that's suing me, right? Because you have like the law firm on the document as well as the plaintiff on the document.
Right.
So
And I can tell you that's one area I see people have a lot of confusion is they think that the law firm is owning the debt. And in most cases, the lawyers are just hired guns. As they say, they've been just like anybody else. They've been hired to handle the case, particularly like the Capital One, Chase, American Express. Often those lawyers are just like the lawyer you would hire. They've just been hired by this company to represent them. So that can create some confusion as well, I see.
right, exactly. Yep. And then yeah, and then even kind of a little bit more of detail. In the law firms, there's usually kind of at least two layers of people that you will work with. One layer is you'll work with the attorney at the law firm that is suing you. That's whose name will be on the document. And then you might deal with the frontline person. So that's not an attorney, that's like somebody paid hourly who's on the floor, they call it, who's like manning phones. So if you call the number, uh, then you'll end up talking with somebody on the floor, right? We usually don't recommend calling in directly. Recommend using like solo settle to settle, or number one is just responding to the lawsuit. Those are some of the intricacies that we see. John, how do debt buyers purchase debt? Do you know much about that? How they actually purchase?
Yeah, I mean the big, the big like Encore Capital, parent company of Midland. I mean those transactions are huge. I mean we're talking. I think Encore, the last numbers I said, they file half a million lawsuits a year nationwide. So they're dealing directly with some of these big banks and the lenders and things like that to purchase debt. But to your point about how it could be the person down the street, there are platforms where you can go buy debt. I've been on there. They're literally it's like an auction where they're selling portfolios of debt. Maybe I saw one time they were selling old charged off magazine subscriptions that there's money that was owed on. And so surprisingly, there's some licensing requirements, but almost anybody that really wanted to get involved can. There's actually a really interesting book. It's called Bad Paper. I don't know if you've seen that one, George. It's on the debt buying industry. And maybe it's because I'm an attorney nerd who deals with this stuff. But it's surprisingly interesting. This whole debt, it goes over the whole debt buying industry. Talks about a lot of the kind of the dark side of the debt buying industry and things that go on. But so it can be on a huge scale with these gigantic publicly traded companies, but it also can be on a much smaller scale. Like there's a lot of law firms here in Arizona that actually will buy debt in the name of another entity, and then they'll file suit on it. We see that quite as well.
Fascinating. I'll have to take a look at that Bad Paper. That sounds interesting.
No.
Yeah, certainly. Right. There's websites where you can just buy debt, right? I forget the names of them, but I've been on them as well. Right? You'll look at usually the collector will buy a portfolio, so they might buy like 1,000 accounts. The balance on the portfolio, let's say, is like $1 million, and then they'll buy that account. They'll buy that portfolio for some fraction of $1 million, right? Maybe like $10,000 or 100,000. Who knows? It depends on the portfolio.
Yeah.
And it's kind of like storage. the what's that? There's the TV show like Storage Wars where they sell storage units.
Yeah.
You don't necessarily know exactly what you're getting sometimes on some of those auctions where you're just buying a portfolio, and then the collector hopes that they can then collect on those accounts.
Yeah. I've even seen portfolios where they sold them, they're outside the statute of limitations, and they sell them for less than a penny on the dollar. So it's kind of interesting. You see everything from something that's, like that all the way up to, maybe something that just recently went into default, that kind of stuff.
Crazy, crazy. How much do debt buyers pay for these old debt accounts?
I can tell you what I've seen from like FCC reports, Consumer Financial Protection Bureau had some reports. The consumer that may be a thing in the past really quickly. Sounds like the CFPB may be done soon. But so go download all those credit card agreements and everything they have while you can. The one that sticks out for me, Encore Capital, they say on average pays like 4 cents on the dollar, I believe, for their debt. That's Midland credit, Midland funding, that kind of thing. But I think it does vary significantly and can be, like I said, less than a cent on the dollar for things that are outside the statute or debts that may not be real collectible. I can tell you one thing too that I run into a lot with clients, at least here in the courts in Arizona, is that number one, it's highly guarded by the debt buyers, even in litigation. It's not something they usually voluntarily turn over. You have to kind of fight them for it. And I've often seen the courts kind of shrug their shoulders at requiring it to be turned over. Basically, the courts are saying, look, if they can prove that there's a legitimate contract in place, that they purchased this, and they meet all the requirements of this assignment or transfer, then they would be entitled to collect the full balance regardless of how much is paid. So sometimes I do see consumers will focus on that just because it just feels unjust that they're paying nothing for it and they're getting this huge windfall. I haven't seen it be a real strong defense or something the courts are really that interested in diving into more than the actual making sure the underlying contract is valid. The amount paid, it's interesting, it's infuriating, but at the same point, it may not be overall super relevant to what you're trying to do and trying to get your case, taken care of.
Right. Right. I think some people mistakenly think, oh, the debt buyers on average buy the debts for 4 to 8% of the face value. Therefore, I should settle for 9%. That's just not going to happen. It's just not the case. It's like if you're buying a car, right? A retail car. Maybe the dealership bought the car for 20,000. They're listing it at 40,000. You're just not going to get the car for 21,000. Not something the dealership's going to do. You might get the car for 30,000, but you're not going to get it 21,000, right? If a debt collection company, especially if you're dealing with one of like the main companies, if they settled an account for 9%, they're going to be out of business by the end of the year. Right? They're going to be bankrupt, and they're not interested in doing that. So it's more like cases are going to settle, between 45% on the low end up to like 85%. But in reality, even beyond that, settlement range is 0 to 150%. Sometimes is what we see, right? We've seen debts be forgiven. We've seen collectors forgive debts for exceptional medical hardship, and sometimes we've seen people settle even above the initial balance because the balance is accruing while the lawsuit's ongoing, and they just want to get it done. Settle it. Great. We have lots of questions here on the chat, so let's take a look. We got our friend Masks for the Homeless is back again. What's up? Masks for the Homeless in Jersey City, New Jersey. How long is consumer bad debt sellable, even after the original reports the write-off to the credit bureaus? So I guess he's wondering how long can people, how far down the road can the debt be sold?
Well, it could be sold at any point. You're not going to see it sold before the 6-month window for the charge-off. But I mean, like I said, I have seen that that's outside the statute of limitations. So like Arizona, 6 years on a credit card. And so, I may see a debt that's 15 years old, and they're still selling it to subsequent debt buyers. If you do get, and so they know they can't sue, but there's nothing that says that they can't just send you letters and ask you to voluntarily pay. And that's, I talked about that one magazine subscription case I saw. That was something where someone bought these old outside the statute magazine subscriptions, and they were just sending letters. I mean, the letter said, hey, we can't sue you, but you want to voluntarily pay. And enough people pay that it makes it worthwhile for some of these collectors. So yeah, do I see them 20 years down the road? Usually no. But it's still possible that they could be sold well outside the statute of limitations. You're going to see the bulk of it. The majority of what I see is, within, it's sold about the 6 month period, probably about 4 or 5 years, that time frame.
Yeah. And the statute of limitations on judgments can be quite long, right? So, that point aside, do you know if collectors can sell judgments?
Yeah, I actually have a case right now where they did. Where it's a 2012 judgment that was entered by one debt buyer, and then it was sold to another debt buyer, like in 2021, I think. And so they come in and they can substitute the parties with the court. So, and to your point, like in Arizona, judgments are good, civil judgments are good for 10 years. And then they can be renewed for an additional 10 years, really for the rest of your life. And so there's even a market in the debt buying world where some debt buyers, I don't see it with the big buyers, but there's other kind of more niche debt buyers that go out and buy this paper, and then they just get substituted in for the plaintiff so they collect on it.
So portfolios of judgments are sold.
Yeah. I see that. Not frequently, but I see it enough that I know how it happens.
Interesting. Yeah, I wonder if those are sold. I imagine those are sold pretty high on the balance. I imagine those are sold at a higher percentage because the collector can file for garnishment.
Yeah, they can jump in and immediately garnish. It's probably a lien against any real estate that the person may own. Bank levies. I mean, in some states, personal property, they can go after. So I mean, it's not a guarantee, but they've gone. The initial creditor has taken all the hard steps, doing the litigation process, getting the judgment, and then trying to just selling it off. It's probably would sell at a higher rate.
Totally right. Yep, and I mean, we've talked with lots of customers who are surprised or blindsided when they're sued for a debt that has a 10-year-old judgment on it. Right? It's like going to expire in a couple months, and then they get sued, or they don't get sued, but they get a garnishment filed against them at that point.
Yeah.
Let's see, another question coming up. If a collection agency purportedly bought my debt, refuses to provide a copy of their master purchase agreement with the debt seller to prove they bought my specific debt, can I sue that agency?
This comes up in lawsuits quite a bit, where they file the complaint, or they file the petition with the court. Sometimes they'll attach just a kind of a generic bill of sale. It doesn't reference the consumer, doesn't reference their specific account. It'll just say we sold a portfolio of accounts. And it'll say, look on Exhibit A, and you look at Exhibit A, it's like all redacted. There's nothing there. But they always reference a master purchase sale agreement or forward flow agreement, and that contains really the details of what was sold. And they don't want to turn it over. All debt buyers claim this is there's sensitive business information there. There should be some kind of privilege attached to it. I've fought that battle numerous times. Usually, I'll send over a written discovery request. They say no, and then we have to actually take it before the judge. In my experience, at least Arizona judges are saying, yeah, you got to turn it over, because sometimes they say, oh, it's not relevant. It's absolutely relevant. It's the only reason why we're here, because this is what they're claiming gives them standing before the court. Because at the end of the day, they didn't loan you money. You didn't agree to pay them money. They've got to have some documentation to support their argument as far as why they can sue you and collect from you. I have found if a judge tells them that they have to turn it over, my experience was just anecdotal. The debt buyer almost always just dismiss it. They would rather dismiss one case, they'd rather lose this little battle than lose what they see as overall war, because they don't like those forward flow agreements out there. I think truthfully because they don't want their competitors to see the details of their agreements with the creditors. But if you do get it, and I have received them, the way that they can help you truthfully is the amount of disclaimers in there. Is that the original creditors often have these waivers and disclaimers saying, look, we don't guarantee that any of these numbers are correct. We don't guarantee that the interest rates were calculated correctly. Basically, they just try to say, look, we're not saying it's on you. We're selling this as is. Junk debt buyer, good luck with it. And that can be helpful in trying to get cases settled, or if you're litigating a case of saying, look, they don't even know if the information that they're suing us on is accurate.
Definitely. That was a great answer, though. You're saying there are two agreements here. You're saying that oftentimes the collector will try to show like a general purchase agreement for the portfolio, and they will try to not show the individual documents of the purchase, like it for that individual trade line or account.
Yeah, so usually with the lawsuits, there's a very, it's usually a 1 to 2 page, just says bill of sale. It's clearly an exhibit to some other document. It'll even say like exhibit D or whatever, and they'll be page 20 or 40. And it's just a generic saying, hey, whatever. Santander sold a group of accounts over here to Portfolio Recovery Associates. The accounts are listed on Exhibit A attached here too. And then you look at Exhibit A, it's just redacted. Sometimes they'll do a recreation of what they say is extracted information from that file. But you're not getting the actual contract between the creditor and the debt buyer. The courts recognize this, that these two gigantic companies are not selling, $1 million worth of debt with a two-page document. It's a very in-depth contract, and it usually governs several different portfolios, not just yours. And so they don't want that master purchase and sale agreement out there. But like I said, most courts I've seen, if you go and get an order from the court, order them to turn it over, they'll do it, because it's hard for them really to argue it's not relevant, because it's really at the core of the case of why they can even sue.
Oh, fascinating. Okay, we have another question. Let's see. Looks like some people are saying there's an echo. Sorry about any echo here, folks. I'm not seeing any echo on my end, clearly on the audio. Let's see. Could you put, somebody asked for the name of the book. It's called Bad Paper. Okay.
I think it's like Jared Halprin or somebody who's by.
Yeah. So we have a question from
Jake Halprin.
Jake Calprin. We have a question from Favorite Amazon's Best. What does it mean on the court's own motion non-jury trial was scheduled on a certain date? Does it mean the court is the one who decided for this trial? The plaintiff bank gave no action. A little bit tricky to decipher there.
Yeah, I mean, what it could be saying is the court can they call it sua sponte, the Latin the most courts use, where they're saying that they're taking some action independent of the parties. And it may be that, for in that jurisdiction, they're setting a trial date without really consulting the parties, saying, hey, we're going to put this on the calendar and move forward that way. I see that with courts, particularly our justice court system that deals with the kind of smaller cases. They will do that just to keep the cases moving through the court system without actually reaching out to the parties or waiting for the parties to ask for the court to set a trial date.
Okay, great. Truth Futurist said slavery was legal before humanity woke up. I think suggesting that debt collection will be illegal at some point in time. Might be a little bit of a stretch, truth, but maybe we shall see. Can I settle my debt before the trial?
Yes.
Yes.
Settlement can occur at any stage. Before a lawsuit, during a lawsuit, before trial, after judgment. I always say if they want money, and if you're willing to offer money, there's got to be some kind of deal that can be reached. And so, many trials, many cases are settled. They, on the courthouse steps, as they say. I've had numerous cases settled as we're walking into the courtroom to do trial. So, not only that, if you're representing yourself and you're dealing with one of these large debt buyers, the law firms that are handling these cases, they often have relatively few attorneys for the number of cases they're handling. And sometimes the attorneys really haven't dug into the case until later on in the process, or even as you're walking into trial. And so they may be willing to say, hey, let's just get this done. Because it's really their first time putting a lot of time into the case. So settlement is available at any time. It's not something, even if judgment, even if you've lost a trial, there's always a deal to be reached.
Question from Lauren. How do I pay my filing fees? I was sued and paid solo suit to file, but I was denied the waiver. I'm finding it impossible to find out how to pay. Lauren, glad to be a message. Happy to help you out here. Let's see what what we've said in the chat here. Lauren, we've probably sent you quite a few emails with a link to payment to pay the filing fee. If not, email us at support@solosuit.com and we will respond to you with a payment link where you can pay the filing fee, and then we will transfer that fee to the court and refile the document for you. Yeah, Orange County, California is pretty difficult to work with. Probably the hardest court in the U.S. to work with, unfortunately. So I don't know if anybody's elected over there that you can change out or try to get different election over there. But Orange County, California court is the hardest court to work with on these cases in the United States. So hopefully we can get that through. What we do, that said, we do file into that court with frequency. So yeah, send that email and then we will get that taken care of for you. Anthony asked, can I file an answer into the court in Virginia? Yeah, definitely. You can use Solo to file an answer into your court in Virginia. Let's see. We have time for one more question. Calissimo, can the court dismiss a case when the plaintiff files the lawsuit in the wrong jurisdiction, according to where I live?
So it was filed in the wrong jurisdiction. So I don't think I heard the last part of that.
Yeah. Yep. So Calissimo saying there is like alleging the case was filed in the wrong jurisdiction. Can the court dismiss the case?
The court can. I mean, if they sue you in the wrong county, I mean, they usually have to sue the defendant where the defendant lives. And so if they've sued you here, Maricopa County is where Phoenix is, but if you live in Maricopa County and they sue you in one of the neighboring counties, you can file a motion to dismiss. It's not something that the court investigates on their own. It's usually something you have to file a motion. It usually results the court will say, okay, they can transfer it over to the other county. But it is a reason that you could have the case dismissed. But you usually have to do something to ask the court to do that. They don't usually do it on their own unless a clerk happens to catch it or something like that.
Right. And my understanding is pretty much always the appropriate venue for these cases is the court where the consumer now lives. Is that right?
Correct. And that's where you're usually going to see it. That being said, I have seen it where they filed in the wrong venue in the wrong county. Truthfully, that's where a lot of the defaults end up from, and that may be a reason to unwind something if you have a default against you later on. But yeah, it's generally where the jurisdiction where you live is where they've got to bring the suit.
Right. So if they're suing you like in the place where you got the credit card but you moved, or they're suing you in a place where you used to live, the appropriate venue is where you now live. So you can totally file a motion for you can file a motion for dismissal. Probably what's more appropriate is a motion to change venue. Right? Motion to change venue to the place where you currently live. If you just file for dismissal, they're probably just gonna file the lawsuit again in the place where you do live.
Yeah. I mean, it can be something to give you a little bit of leverage. Technically, it's a violation of the Fair Debt Collection Practices Act for them to sue you in the wrong venue. Like I said, usually the court will remedy it by allowing them to transfer it if it was kind of honest mistake kind of thing. But it could be something where, like I said, I don't know a lot of FDCPA work, but I do know that filing it in the wrong venue, particularly if you can show that they knew where you lived, could rise to some liability for them and give you a bit of leverage to maybe get it settled.
Great. All right, John. Well, that's all we have time for today. Where can people find out more about you?
Yeah, my law firm website is consumerwarrior.com. Particularly if you're in the state of Arizona, you need legal help. I do free consultations, consumerwarrior.com, or just look up Consumer Warrior on YouTube, and you'll find me there somewhere.
Sounds great. All right, sounds good, John. Very good to see you. Thanks for coming on, everybody. We are in your corner, and we're hoping that you win and get the best resolution available to you. So